交由內務委員會處理。本會現在恢復2014年司法雜項條文條例草案嘅二讀辯論。審議上述條例草案嘅委員會主席郭榮鏗議員就委員會嘅報告向本會發言。郭榮鏗議員。
Thank you, Acting President. In my capacity as the Chairman of the Bills Committee on Administration of Justice, Miscellaneous Provisions Bill 2014, I'd like to report on the major deliberations of the Bills Committee. The Bills Committee has held 4 meetings with the Administration and the Judiciary Administration to examine the bill which seeks to amend various legislation to implement various proposals relating to the administration of justice. The Bills Committee notes that Part 2 of the bill amends the definition of live television link by replacing the reference to a closed-circuit television system by audiovisual facilities in the evidence-taking process for criminal proceedings. Some members have relayed the concern of the Hong Kong Bar Association about the security issue that may arise from replacing the expression closed-circuit television system by audiovisual facilities. These members have suggested that the judiciary should consider the drafting of the proposed amendment to the effect that the consent of the Criminal Court Users Committee should be sought before any facilities, regardless of the technology used, could be introduced by the judiciary in the evidence-taking process. According to the Judiciary Administration, the Users Committee is a non-statutory committee. The judiciary does not consider it appropriate to prescribe in the law the role of this committee relating to the choice of audiovisual facilities. To address members' concern, a committee stage amendment will be moved to the effect that such facilities should be subject to the approval by the Chief Justice. Administratively, the judiciary will seek views from the relevant parties, including the Users Committee and others, for the Chief Justice's consideration before his approval. The administration has also agreed to introduce committee stage amendments to address the Bills Committee's concern about the textual inconsistency between the Chinese version and the English version of the proposed amendments regarding the definition of live television link, and to refine the drafting of the legislative provision having regard to members' comments. The Bills Committee notes that Part 4 of the bill amends the District Court Ordinance so that the reasons for the verdict may be delivered either orally or in writing, while the reasons for sentence will continue to be delivered orally before they are reduced to writing. Some members opine that the proposed amendment allowing the district judge the flexibility to hand down the reasons for verdicts in criminal proceedings in writing direct would prejudice the rights of the litigants. These members also opine that the judiciary should consider setting out the relevant factors that should be considered by the district judges in deciding the mode of delivery of reasons for verdicts. Given the members' preference and after careful consideration, the judiciary has agreed that it will set out by way of a practice direction the relevant factors that a district judge may consider when deciding whether the reasons for verdicts should be delivered orally first or directly in writing. Some members of the Bills Committee have suggested that a copy of the reasons for the verdict delivered directly in writing should be made available to the public through the Internet. In addition, the reasons for the verdict delivered orally and then reduced to writing should be disseminated in similar ways as those directly delivered in writing, and by way of making a copy of such reasons to the public through the Internet. The administration has agreed to move committee stage amendments to this effect. The Bills Committee notes that Part 5 of the bill repeals a section of the Hong Kong Court of Final Appeal Ordinance to abolish the existing as-of-right appeal mechanism for civil causes or matters to the Court of Final Appeal and make certain consequential amendments thereto. Some members have expressed reservation about the proposed abolition of the as-of-right arrangements for civil appeals. Some members note that if the as-of-right appeal mechanism is to be abolished, leave to appeal to the Court of Final Appeal will only be allowed if, in the opinion of the Court of Appeal or the Court of Final Appeal, the questions involved is one which, by reason of its great general or public importance or otherwise, ought to be submitted to the Court of Final Appeal for decision. These members opine that the factors that may be considered by the judges under the or otherwise provision should be spelled out more clearly under such circumstances. The judiciary has advised that in other comparable common law jurisdiction, there is no automatic right of appeal to the highest court. The The judiciary has also examined the relevant cases and summed up the factors and circumstances under which leave has been granted under the or otherwise limb can broadly be grouped into three categories. These include legal errors causing grave injustice, relatively important subject matters, and miscellaneous matters. The judiciary has stressed that the decision to grant leave is typically fact-specific. Any categorization of the factors or circumstances under which leave was granted by the court can only be a broad guide. If the bill is passed under commencement of the Part 5, all appeals in civil matters to the Court of Final Appeal would be subject to discretionary leave. Acting President, next I would like to give my personal views on the issue concerning the appeal to the Court of Final Appeal. This bill raises important issues relating to the administration of justice. This includes allowing the use of more advanced audiovisual technologies in the evidence-taking process for criminal proceedings, which we have just touched on. And on behalf of the legal profession, I'm especially grateful for the administration's acceptance of my suggestion to move a CSA to ensure that the reasons for the verdict for cases in the district court would be made available to the public through the internet. I believe this would be of immense help to the legal profession, the clients, as well as the general public. Unfortunately, this bill is not without controversy. In particular, as I've mentioned, the point on the abolition of the as-of-right appeal mechanism has been received with some skepticism. It must be acknowledged that the reservations raised against the proposal are not without merits or logic. As-of-right civil appeals alleviate the restrictions from existing rights of appeal, which is a matter of particular concern to litigants in this jurisdiction. For instance, I note that a number of civil appeals reached the CFA through the as-of-right provision under Section 22, subsection 1, subsection A of the Hong Kong Court of Final Appeal Ordinance. In 2012, out of 27 civil cases filed in the CFA, 6 were as-of-right appeals, and of these 6 cases, 2 were successful. The as-of-right appeal mechanism is also consistent with Article 35 of the Basic Law, which provides for the right to access to the courts and judicial remedies. While the Court of Appeal safeguards this right, there's a sentiment that all avenues of legal recourse should be pursued before justice is considered to be served. Although I'm sympathetic with litigants who share this point of view, it must be remembered that limitations of appeal to the CFA serve the legitimate purpose of enabling our top court to focus only on judgments which are of particular importance. In fact, not only is there doubt as to whether an as-of-right appeal mechanism founded on the $1 million monetary threshold can help secure proper and efficient administration of justice. It may even make matters worse for the following reasons. Number one, the appeal mechanism is objectionable by principle. The $1 million monetary threshold is an arbitrary figure which establishes an exclusive privilege to appeal. This suggests unacceptably, in my view, that monetary figures give rise to rights. When the CFA ordinance was passed in 1995, there was a proposal to repeal the as-of-right mechanism for this very reason. It was not repealed at that time primarily because the then AG claimed that such a move would be a radical departure from the then existing system of appeals to the Privy Council. As we know, Hong Kong's judiciary has matured significantly since that time, and parallel changes are necessary in order to accommodate such developments. Secondly, the appeal mechanism is strange in our modern judicial system. As-of-right appeals to the highest appellate court are not features in the legal system of common law jurisdictions that are comparable to Hong Kong. Leave must be obtained for appellate cases to the Australian High Court, to the New Zealand Supreme Court, and the UK Supreme Court. In Canada, leave to appeal has been required in most cases since 1975. While Singapore and Ireland retain as-of-right appeals, it is because their judiciaries do not have intermediate appellate court. As a matter of fact, the Singapore Court of Appeal has explained that, as a general rule, there should only be one tier of appeal as a matter of right. Thirdly, not only does the appeal mechanism lead to an ineffective appeals system, but it also unnecessarily drains judicial resources. For instance, the as-of-right appeal mechanism has repeatedly led to a situation where the CFA has had to consider and hear unmeritorious appeals. These cases benefit neither the respondents nor the appellants and only serve to increase the legal costs for litigants. More importantly, they lead to delays or possible denials of hearings of meritorious cases. Unmeritorious cases have regularly been held by the judiciary to be a waste of both judicial means and time. Acting President, the judiciary has frequently pointed out that the as-of-right appeal mechanism would often give rise to problems in actual practice. Last September, the Chief Justice dismissed an as-of-right appeal, saying that in the judgment that if leave to appeal had been required, there is no doubt that such leave would not have been granted for this case. He also remarked that this is yet another all too common example of an unmeritorious appeal, which has reached the CFA by this route. The Chief Justice's criticism echoes the sentiments of other CFA judges, such as Justice Ribeiro, who accurately observed that the role of the CFA isn't to let litigants have a third bite of the cherry. Last but not least, the as-of-right appeals create room for an abuse of the process. It makes it possible for litigants with more financial resources to bring the case and litigate matters all the way up to the CFA, regardless of the merits or the issues involved in the case, just to gamble on the possibility that the other side, who may be less wealthy or has less resources, would fail to secure enough resources to hire lawyers to argue the case all the way up to the CFA, thereby forcing early settlement of cases. Given Hong Kong's current levels of economic inequality, this unfortunately happens way more often than one could imagine. You can see from these points how as-of-right appeals for civil matters hinder our judicial system and is oppressive, sometimes is oppressive, to litigants who have won in the Court of Appeal twice, once in the Court of First Instance and second time at the Court of Appeal. It is equally obvious how the issues give rise to injustice by denying more meritorious, if not numerically less significant cases for reaching the CFA. The law should not be more favorable to those with means to take advantage of the court's procedures. The time to abolish the as-of-right appeal mechanism for civil matters is long overdue, and the court of last resort should be permitted to conduct affairs befitting to its purpose and serve litigants equally. As an end note, I would like to say that many of my colleagues, including those within the Civic Party, believe that the test for the CFA leave to CFA is excessively strict and should be revisited. I'm talking about the leave to appeal mechanism. However, I'm equally of the view that this concern can be addressed without compromising the bill. A practical remedy is to elaborate on the or otherwise ground of leave as per Section 22, subsection 1, subsection B of the existing ordinance, as opposed to the part of the provision covering leave for matters of great general or public importance, or otherwise is comparatively vague and unclear. The judiciary has come up with the general definition of this or otherwise limb, comprising three categories of cases. Number one, legal errors causing grave injustice or different results. Number two, relatively important subject matters, and number three, miscellaneous matters that are of logical consequence to other court orders. But a much more detailed explanation and jurisprudence is desirable and necessary for future development of our current judicial appeal system. This is especially clear when one compares with the test adopted in foreign jurisdiction. For instance, neither the High Court of Australia nor the Supreme Court of Canada phrase grounds of appeal in such loose terms as or otherwise, quote and unquote. In the High Court of Australia, the Judiciary Act empowers the High Court to have regard to whether a question of law is required by the final appellate court to resolve differences of opinion between different courts or within one court, or whether the interests of the administration of justice require consideration by the High Court in granting leave. Similarly, in Canada, the Supreme Court grants leave if it is of the opinion that by reason of the importance of any issue or law or mixed law and fact involved in that question, one that ought to be decided by the Supreme Court or is for any other reason of such nature or significant as to warrant decision by the Canadian Supreme Court. Ultimately, the threshold for leave should be mitigated to ensure that litigants are not deprived of access to the Hong Kong's highest court of appeal. Reference to foreign legislation can inform the expansion of the or otherwise ground of appeal so as to relax the present stringent tests currently imposed by the CFA. It is to be hoped that with the passage of this bill, the judiciary would go on to address the issue in due course, whether it is in subsequent judgments, explaining further the use of the or otherwise ground, or in expanding the current jurisprudence regarding the grant of the leave to appeal. Acting President, those are my personal views on the bill. I understand that my fellow members, including those in my party, would speak and perhaps differently on some of the issues involved in this bill. But those are my views, and I ask that this bill be considered carefully by members of this legislature for reasons that I have mentioned earlier. Thank you, Acting President.
鄧家彪議員。
多謝代理主席。今日當局提交2014司法雜項條例草案，主要係為咗改善法庭運作而提出各種嘅修訂嘅措施，當中包括多個法院同埋審裁處嘅條文。身為勞工界議員嘅同埋勞工界嘅代表自然係關注當中關於勞資審裁處運作嘅相關條文，所以我係參加咗條例草案嘅審議工作，並喺會上面提出咗一啲嘅問題同意見。當然之前亦都喺司法嘅事務委員會裏面係做咗一個過冷河嘅一個嘅諮詢，我亦都係提出咗一啲嘅意見。喺度係感謝當局採取我哋勞工界嘅意見，尤其喺司法事務委員會嘅階段裏面係將勞資審裁處原本諗住可能係修訂係加入一個限制披露資料嘅條文係刪除，將呢個嘅限制披露資料嘅條文係唔再成為一個嘅草案，因為有關限制確實係會對工會協助工人去爭取勞工權益，以及係工人嘅索償嗰度係有一個好大嘅影響。代理主席，俗語話生不入官門，本身勞資審裁處係一個低成本嘅法庭，希望係唔會阻礙工友透過法庭係尋求佢自己嘅補償，甚至係公義。咁但係其實本身由勞工處或者係出現一啲勞資糾紛，去到勞工處，再去到法庭，即係勞資審裁處登記落案，再完成一個嘅審訊冇半年亦都有，即係冇1年都有半年，係一個好漫長嘅時間嚟嘅。咁所以如果勞資審裁處嗰個嘅法例或者喺程序上面係做得唔夠妥當，或者係一啲客觀上面嘅條文係對打工仔走入勞資審裁處係造成一啲限制或者係不鼓勵對打工仔對工會嚟講都唔係好事，所以我哋係十分之敏感。根據司法機構嘅數字，2013年勞資審裁處個案係有4315宗，當中絕大部分係屬於有金錢嘅申索嘅個案。而家唔少基層打工仔喺處理勞資審裁處嘅法律程序，以至應訊嗰陣時都會係向工會尋求協助，並且係向審裁官尋求同意，係委託工會，即工會嘅代表係代表呢位申索嘅打工仔喺審裁處上面係發言嘅。而工會喺協助工友處理個案，當然會涉及到僱主或者係呢間公司裏面嘅一啲嘅文件、一啲嘅合約、一啲可能係涉及到行政人士。舉個例，簡單到一張編更嘅表， 咁有時工會要求證究竟工友嘅申索係咪有理有據、依足法例，甚至係合約上面已經係承諾嘅，自然會尋求呢個申索工友嘅其他同事嘅求證或者係問意見。咁所以呢，如果根據當局原先嘅建議，裏面其中一個修訂就係頭先我一開始所講限制披露資料嘅規定，就係話呢，除咗勞資審裁處嘅法律程序目的以外，都不可以披露涉及文件及資料予其他人，否則將構成藐視法庭罪而須負上法律責任。如果呢個修訂真係出現嘅話呢，我哋好憂慮呢，工會根本唔能夠協助工人，工人亦都唔敢求助工會，因為會將呢啲咁嘅資料一俾咗工會，會唔會就變成藐視法庭呢？咁當然個官未必咁睇，但係僱主可能會即時向個法官投訴，工友將公司嘅資料俾咗工會睇，咁啊我認為佢藐視法庭，咁都已經係令到工友係卻步。咁所以我哋對於本身原有嘅呢個建議係十分之憂慮嘅。我又舉一個例子啊，譬如我哋處理一間酒樓員工欠薪嘅個案嗰陣時，可能係得一個呢工友嘅求助，但係工會對於酒樓欠薪係好敏感嘅，咁會了解究竟除咗呢一個正式走入法庭嘅工友，佢係咪面對欠薪，都會同時間呢希望了解佢哋嘅同事係咪都係面對欠薪，以推斷究竟呢一個酒樓嘅東主呢個僱主會唔會因為周轉不靈而欠薪，甚至係隨時倒閉，令到所有工友都係有所損失，甚至最終係所謂要用破欠嚟找數，公帑找數。咁所以呢，對於如果走入法庭嘅工友，佢要披露嘅資料俾工會，造成一啲限制呢，我哋認為根本係綁住工友，亦都係綁住工會嘅一個嘅做法。所以對於政府喺司法事務委員會嘅階段聽咗我哋嘅意見，同意剔除或者係抽走呢一個喺勞資審裁處裏面限制披露資料嘅條文，我哋係表示十分之歡迎，亦都肯定你哋對我哋嘅尊重。我哋呼籲政府當局，如果再想提出，係一定要同勞工界做一個深入廣泛嘅諮詢，而唔係呢就咁用一個書面嘅回條問勞顧會嘅委員，問你哋有冇反對，都冇人知究竟發生咩事，一次會議都未發生過，就話呢冇反對，咁樣係唔得嘅。至於喺今次嘅雜項條文裏面，亦都有一個部分係關於勞資審裁處，我哋工聯會或者工會都係有所顧慮嘅，就係喺保證金嘅制度。喺勞資審裁處條例第30條，有關條例涉及命令繳存款項喺勞資審裁處或提供保證。事實上呢，有一啲嘅僱主呢就好懂得運用財技，喺俾打工仔申索嘅時候，可能係會將資產轉移調動，又或者呢係濫用司法程序，一拖再拖，去拖延嗰個嘅聆訊或者應訊嘅過程。於是呢，就有咗第30條嘅規定，列明呢審裁處可以要求被告人係繳存足夠嘅款項，又或者係提供足夠嘅保證。代理主席，呢個事實上睇落去係合情合理嘅訴求，因為無論打工仔同法院都唔想有一啲嘅僱主喺被控嘅期間突然之間一走了之，或者係轉移資產，令到頭嚟呢，就算作咗裁決，亦都起唔到作用，或者又係最後要破欠找數累及公帑。咁所以就有個咁嘅條文。但係呢，今日條例嘅修訂裏面呢，有啲嘅加入咗新嘅理由，例如呢，喺第30.1條中呢，提供保證即係保證金嘅人呢，由被告人改為命令任何一方，即係就算話呢個申索原本係由僱員訴僱主大家以為呢通常都係審裁處嘅法官要求僱主提供保證金，就變為呢僱員僱主都有可能被審裁官呢係即係有個咁嘅命令。咁所以呢個係我哋憂慮嘅。新嘅理由呢，包括呢就係頭先我所講啦，被告人將財產移離香港啦， 及任何一方濫用勞資審裁處嘅法律程序，以及沒有遵從勞資審裁處嘅裁斷、命令或者指示等具體嘅條件。對於新條文之中要求僱員繳納保證金嘅問題或者可能性呢，我曾經喺審議條文嗰陣時咧，其實已經係無論口頭定係書面咧，都向當局查詢。但係當局嘅回覆就係話啦，其實過去就算有冇修例，都一直係有審裁官係要求僱員繳納保證嘅。而如果繳納保證金嗰陣時有疑問呢，有關人士可以作出覆核或者上訴。所以其實本身呢個制度係令人憂心嘅，因為審裁官係喺記錄上係的確係已經係叫打工仔咧係俾保證金，但係咧可能嗰啲嘅個案呢係僱主訴僱員，譬如話追一啲所謂突然離職嘅代通知金。咁而家呢個修訂咧就變為咧任何一方，咁即係話咧僱員可能俾審裁官要求命令俾一個保證金嘅機會咧就再大咗。代主席先生，我嘅擔心呢，喺根據一啲嘅我哋服務嘅個案呢，其實係真係有理由嘅。我哋工聯會底下有個勞工服務中心，裏面呢個中心裏面有幾個同事真係協助求助工友呢，係陪佢哋上法庭，協助佢哋呢係處理一單單走咗入去司法走咗去勞資審裁處，去到聆訊階段陪同佢哋，甚至係出席協助發言。咁呢啲同事同我哋反映呢，佢係最近呢2-3年呢，佢係睇到勞資審裁處係的確多咗嘅個案呢，係要求呢僱員係俾保證金嘅。以一個嘅例子呢，就係話呢有一個工友呢係申索10幾萬嘅欠薪，以及係代通知金。喺申索嘅頭嘅階段呢，嗰位嘅審裁官呢，竟然喺一開始認為咧呢個工友可能勝訴不足，要求咧佢先俾8000蚊嘅保證金。咁最後點呢？其實最後呢位工友係贏咗嘅，因為咧佢提供嘅證據甚至係人證啦或者物證咧係十分之充裕。咁審裁官亦都合情合理咁作出一個工友勝訴嘅裁決。但係我可以睇到咧，原來唔係工友被告。原來而家審裁官已經有個咁大嘅任意性，中意邊個要俾就俾。咁所以雖然睇落去呢個條文呢係明確咗一啲嘢，但係其實我哋前線服務嘅經驗話俾我哋聽呢，審裁官嘅任意性好大。咁所以呢，對於呢一次嘅修訂呢，我哋抱住一個係觀望嘅態度。咩意思呢？就係話其實現實上審裁官已經有好大嘅權力去處理呢個保證金嘅命令。我哋覺得或者睇到條文係清晰化咗或者合理化咗一啲大家都公認係合理嘅理據，舉個例拖延法律程序啊，或者可能係轉移資產，令到我哋有信心呢個條文係的確係比較有利打工仔。但係喺實踐起上嚟又的確咧有好多令我哋憂心嘅地方。但係我哋本住權衡整個嘅司法雜項條文係一個一籃子嘅修例，亦都本住其實本身現在已經有保證金嘅呢種做法呢，我哋對呢個嘅法案都係會予以支持。但係喺度敦促當局，第一就係要建立一個資料庫，係能夠話俾我哋聽，究竟喺勞資審裁處裏面過去以及嚟緊命令保證金嘅情況，有幾多係僱主，有幾多係僱員，個金額如何？命令咗之後，究竟係邊一方勝訴？我哋好希望你能夠建立呢個資料庫，話俾我哋嘅打工仔同埋工會知道呢，政府所做嘅修例繼續會係令到勞資審裁處係能夠顧及到我頭先一開始所講，係一個低成本，令到打工仔有信心走入法庭去解決佢僱傭關係所衍生嘅糾紛問題。亦都喺度呼籲同埋邀請當局，如果呢個法例最終獲得通過，希望你哋就住保證金嘅呢個制度過去嘅經驗，嚟緊你嘅諗法係實實在在咁樣同唔同嘅勞工團體係有一個深入嘅溝通，俾到我哋一個保證。我當然亦都係盼望司長可以喺一陣間嘅回應裏面係可以回應到我呢啲嘅憂慮。代理主席先生，本人支持條例草案恢復二讀以及三讀，謹此陳辭。
廖長江議員。
主席，本人係贊成廢除香港終審法院條例第22條1A， 關於將所涉及嘅款額或者價值達100萬元或以上提出嘅民事訴訟上訴呢，視為一項當然權利而受理。經過改革呢，會使到所有終審法院嘅民事訴訟案上訴呢，均要得到上訴法庭或者終審法院酌情給予許可嘅情況之下呢，先至可以提出。主席，喺1997年香港回歸之後，根據香港基本法第8條，香港嘅原有法律，即係基本法、行評法、條例、附屬法例同埋習慣法，除咗同基本法相抵觸，或者經過香港特區立法機關作出修改嘅之外呢，係予以保留。所以香港係繼承咗同埋延續咗英國樞密院司法委員會嘅上訴制度中嘅當然權利。但係隨住時代嘅變遷，幾近每一個同香港有緊密聯繫嘅普通法國家呢，包括英國、澳洲、新西蘭同埋大部分經加拿大最高法院處理嘅案件呢，都係廢除咗當然權利。目前香港係仍然保持民事訴訟上訴嘅當然權利，係未能跟進主要普通法地區嘅發展，係現代主流普通法司法系統嘅異類。然而廢除當然權利並唔僅僅係要同其他普通法系嘅國家看齊，而係出於法理上嘅需要。現存嘅制度將一個上訴權利同埋一個主觀嘅金錢限額，即係港幣100萬元掛鈎，實際上係使到超於金錢限額嘅上訴人，比其他較小額嘅上訴人呢，係擁有更多嘅權利。上訴案件嘅衡量標準應該係案件本身嘅理據，而非係既定嘅金錢限額。喺當然權利之下，冇上訴價值嘅案件能夠直接喺終審法院受理，而循此路徑提交終審法院嘅上訴案件呢，好多可能都係缺乏上訴理據。咁樣做係嚴重妨礙咗香港法律上訴系統嘅效率，不僅導致案件延期，因而否定司法正義，法院無法及時庭審其他更具充分理據嘅上訴案件，特別係公法領域嘅案件。呢啲係對香港司法系統嘅濫用，係對公共資源嘅嚴重，係公共資源方面嘅嚴重浪費。主席，值得注意嘅係呢，提高金錢限額呢並唔係一項選擇。金錢限額嘅適當標準係難作定奪嘅。況且提高金錢限額喺實際上呢，係咪能夠顯著減少無意義嘅上訴案件呢？係非常值得懷疑。反對金額限額嘅存在嘅根本原因呢，係如上所述，係上訴權利同埋金錢限額嘅連結。提高金錢限額唔能夠根治上訴權利同埋金錢限額嘅不合理連結問題。此外，廢除民事案件上訴中嘅當然權利呢，係有助有效咁整合香港司法系統民事、刑事嘅上訴機制。喺刑事上訴系統下呢，上訴權利係完全取決於上訴案件本身嘅理據，係同任何金錢限額係無關。所以，主席，我係贊成廢除香港終審法院條例第22條1A 下嘅當然權利。呢個唔僅係出於法理上嘅考量，而且係更符合公眾利益，同埋有助香港司法系統同埋法治嘅健康發展。謹此陳辭。
仲有冇其他議員想發言？如果冇，現在請政務司司長發言答辯。喺政務司司長答辯之後， 辯論即告結束。政務司司長。
代理主席，首先我要衷心感謝2014年司法雜項條文條例草案委員會簡稱法案委員會主席郭榮鏗議員及各位委員喺審議2014年司法雜項條文條例草案簡稱條例草案時所付出嘅努力，令條例草案嘅審議工作得以順利完成。法案委員會舉行咗4次會議，對條例草案嘅條文作出詳細及深入嘅討論。我喺呢度感謝法案委員會嘅工作，亦感謝持份團體同埋人士向法案委員會表達對條例草案嘅意見。政府提出條例草案嘅目的係落實司法機構就法庭運作所作出嘅改善建議，涉及以下範疇：第一，喺民事、重案或者事項中向終審法院上訴；第二，喺刑事法律程序中藉電視直播聯繫錄取證據嘅安排；第三，區域法院喺刑事法律程序中宣告裁決理由嘅方式；第四，符合常任裁判官委任資格所需經驗嘅計算；第五，勞資審裁處嘅運作；以及第六，各個法院、審裁處對訴訟人儲存金嘅管理。喺條例草案審議期間，法案委員會特別關注司法機構有關取消民事事項中以當然權利提出上訴制度嘅建議。事實上，剛才郭榮鏗議員以作為法案委員會嘅主席同埋佢個人嘅發言，以及廖長江議員嘅發言呢，都係針對呢個嘅建議，可見呢個議題呢係相當重要嘅。我特別高興係聽到郭榮鏗議員雖然佢反映咗法案委員會裏邊有唔同嘅意見，甚至佢所屬嘅政黨呢，或許對於呢個建議呢都有所保留，但係佢嘅本人呢係同意政府今次提出嘅建議。佢提出嘅理由呢，同司法機構嘅考慮呢都大致係相同嘅。我係想重申呢，提出建議嘅原因係呢個制度喺原則上並不妥當，將上訴嘅權利同隨意定下嘅金錢限額掛鈎嘅後果係不論件案件嘅理據是否充分，只要訴訟人所提出嘅上訴爭議嘅事項所涉及嘅訴訟款額或者價值達100萬元或以上，則終審法院須是提出該上訴為一項當然權利而受理該上訴。呢個實質上令到有關訴訟人所得嘅權利係比申索額較少嘅訴訟人為多。對於訴訟人尋求司法公正而言，呢個係唔平等嘅。終審法院曾經喺多宗案件中嚴詞批評當然權利呢個制度，因為呢個制度會導致法庭聆訊有合理理據嘅案件時係有所延誤，更甚者會導致不公平。亦都係正如好似郭榮鏗議員同埋廖長江議員提出，喺其他同香港制度相近嘅普通法司法管轄區，呢個制度早已被廢除。喺該等司法管轄區中，案件必須先取得許可，然後先至可以向最高級別嘅法院提出上訴。終審法院係香港嘅最終上訴法院，而非與上訴法庭以相同基礎運作嘅第二上訴法庭。喺修訂法例後，只有在上訴所涉及嘅問題具有重大廣泛嘅或者關乎公眾嘅重要性，或者因其他理由以致應交由終審法院裁決時，該等上訴才會由終審法院審理。司法機構曾經向法案委員會提供資料，解釋終審法院及上訴庭也曾純粹基於或因其他理由或者連同其他理由給予上訴許可，因此呢一項建議並不會令上訴人嘅權利受到任何實質嘅損害。司法機構認為不宜喺法例列出批准或者拒絕根據或因其他理由呢個部分提出嘅上訴許可申請嘅考慮因素，因為咁樣做係會減少終審法院處理呢啲申請嘅靈活性。法案委員會亦都關注到喺刑事法律程序中，藉住電視直播聯繫錄取證據所使用嘅視聽設施嘅安全性。司法機構向法案委員會表示，會確保有關視聽設施均配備安全保護功能，亦都會就有關科技設備嘅使用諮詢刑事法庭使用者委員會。 司法機構亦都建議喺法例中訂明有關設施須經終審法院首席法官批准。有關區域法院喺刑事法律程序中宣告裁決理由嘅方式，司法機構接納咗法案委員會嘅提議，喺法例中訂明應透過互聯網向公眾提供直接以書面形式發下嘅裁決理由嘅文本，以及訂明轉為文字記錄嘅裁決理由嘅發布方式應與直接以書面形式發下嘅裁決理由嘅發布方式相若。代理主席，剛才鄧家彪議員關注條例草案有關勞資審裁處條例嘅修訂，特別係保證金呢個問題。根據現時嘅勞資審裁處條例，勞資審裁處有權喺某啲情況下命令訴訟人提供保證金。為咗加大審裁處嘅案件管理能力，條例草案其中一項修訂係修改勞資審裁處條例，賦予審裁處一般嘅權力，讓其隨時可以在任何一方申請或者覆核裁斷或命令嘅程序中，如認為公正同埋合宜，便可命令另一方為裁斷或者命令嘅款項提供保證金。可能作出如此命令嘅情況包括有關一方嘅所涉資產有被耗散嘅風險，該方延誤程序，或者該方喺沒有合理辯解嘅情況下不遵從審裁處嘅指示等。有關嘅建議修訂適用於申索人或者被告人，而勞方同埋資方均可能係申索人或者係被告人。例如資方可以向僱員提出申索，以追討代通知金，或因違反僱傭合約而須支付嘅損害賠償。此外，作為申索人嘅勞方，亦都可能遭到作為被告人嘅資方提出反申索。鄧議員擔心修訂對勞方不公平，我想指出，資方同埋勞方都可以係案件嘅申索人同埋被告人。我哋認為不宜喺法例上對勞方同埋資方作出不一致嘅處理方法，而應該盡量提供彈性，讓審裁處可以按案件嘅個別情況作出最恰當嘅安排。審裁處喺決定是否作出提供保證金嘅命令時，有關一方是否有足夠嘅財力繳付所需款項，係其考慮嘅因素之一。咁樣嘅安排亦都係得到勞工顧問委員會嘅支持。鄧議員發言時表示，針對呢個修訂佢會採取觀望嘅態度，但係希望政府當局係承諾喺條文通過後，需要就保證個案作出統計，或者佢所講嘅建立呢個資料庫。同時亦都係希望政府當局認真考慮設立覆檢機制處理保證嘅問題。由於有關個案係屬於司法機構嘅工作範圍之內，我會將鄧議員有關建立資料庫嘅建議係轉達俾司法機構嚟到考慮。但至於設立覆檢機制呢個建議司法機構曾經向法案委員會表示，正如其他勞資審裁處嘅命令一樣，若勞資審裁處作出要求某一方提供保證嘅命令，該一方可以提出覆核及或上訴。司法機構認為係冇需要另行作出一個仲裁嘅安排，或者如鄧議員所建議設立一個覆檢嘅機制。代理主席，因應法案委員會嘅意見，政府對條例草案提出數項修正案，目的係回應委員嘅建議，以及作出文字修訂。有關修正案均已呈交法案委員會考慮及討論，而我會喺全體委員會審議階段動議有關修正案。代理主席，條例草案提出嘅修訂對於改善法庭有多方面嘅運作非常重要。我懇請議員支持條例草案及我稍後動議嘅各項修正案。多謝代理主席。
我現在向各位提出嘅待決議題係2014年司法雜項條文條例草案，予以二讀。現在付諸表決，贊成嘅請舉手，反對嘅請舉手。我認為議題獲得在席議員以過半數贊成，我宣布議案獲得通過。
2014年司法雜項條文條例草案。
全體委員會審議階段，本會現在成為全體委員會。